just going to get out of here. I'm probably the only one who is not a technology person in the room. So whatever you've talked about for the past 45 minutes, I get zero. Nothing. So here's the basic idea about what Theo has been doing. I've been doing these what's called challenges, regulatory challenges, which is basically anybody in this room can go after a regulation pronounced by any regulator and go to court for it. The way you do this is you have to go downtown all the way to the New York State Supreme Court and file what's called an Article 78 complaint. An Article 78 is the process by which an individual knocks at the door of a judge and basically asks the judge challenge, in fact, eliminate a regulation. The way you do this, and in this particular case, is twofold. The first idea behind challenging a regulation is that a regulator can only regulate. It's a little different in Europe. I've done some cases in Europe where in Europe they kind of let the executive branch do a lot more things. Not here. In the US, a regulator can only act within the framework of a statute, a law that has been passed by a legislature. He is not entitled to get out of the little space that the statute gave him. Okay? So he cannot just step out by even a millimeter to just invent things that he can regulate. So when the regulation popped out, it was based on a statute dated from 2011. The only thing that the statute in 2011 did is that it merged the Department of the Department of Insurance that used to regulate insurance products, including life insurance, health insurance products in New York, right? And the banking department in New York, which regulates banks. The only thing that happened is that the law says, I'm merging the two. That's all it said. It didn't say, I want the regulator to regulate Bitcoin, to regulate vegetables, to regulate fruits. So a regulator, if he's being told you can regulate vegetables, is not entitled to go say, I'm going to come up with something to regulate fruits, right? Which is exactly what the Department of Finance did. To simplify, what they did is they say, I'm just going to regulate something called fruits. Except the statute says, In fact, it said nothing. There was even about fruit, vegetables, there was nothing. And a regulator cannot do that. That's number one. So by the way, you have a very, very short period of time to challenge this. Once a rule is promulgated, you have 3 months to run to court. It's very quick. So what Theo did here, I've only started working with Theo recently, is that on October or something 2015, he ran out to the court within probably a week left from the deadline, based on the promulgation of the rule, which was August 2015, if I remember correctly. So the first idea is, you can tell, we told the judge that you cannot, that the Department of Finance, Financial Services, basically invented something to regulate, and they're not entitled to do that. So that's number one. The second idea is, even if the judge does not buy that, let's just assume, okay? Say, no, Pierre and Ciric, you guys are nuts. You're out of there. By the way, the whole argument of why Bitcoin is money and not money is kind of peripheral to that question. It's not really a question of whatever the characteristics are, it's whatever the statute said to the regulator to regulate, that's the issue. So you have to obviously discuss about what Bitcoin is or is not, but the bottom line is, in 2011, the legislature didn't authorize the regulator to go run and deal with stuff called Bitcoin. It has to be specific about what it needs to regulate. Second argument is, say the judge says, you guys are nuts. There's a second argument that says that even if the legislature, in its wildest dreams, really kind of meant for Losky to do what he did, he has to do this in a proportional, reasonable, and measured fashion. You can't just go wild, to simplify. What that means is when a regulation is promulgated, you have to do so in such a way that is only going to say, resolve what the regulatory problem is, okay, and not go beyond that. Well, the basic argument here is, number one, Losky essentially invented a scheme of regulations that went much beyond the
what do you call this? The traditional money transmitters, right? The Western unions of the world. So they're regulated according to a whole bunch of rules. So here what he did is that he took these rules and essentially made them more complex, more complicated, and the threshold for compliance was much higher. And the regulator cannot do that. The regulator needs to be proportionate in what he does. So the second argument, you see, it's got absolutely nothing to do with technology, zero. It's all about the law that says, if you act, you need to act proportionately. And the second argument is, okay, fine, Bitcoin is a financial product, money, whatever you want. By the way, the key definition in the statute is financial product. It's not even quite money, but that's what the definition is, okay? So even if Lonsky was allowed back then to do that, he has to do this in a proportionate fashion, and that is in and of itself a ground for a judge to throw out the rule, okay? So that's the second argument. The third argument, which is more minor but is important in front of a judge, is to explain why Theo has what's called standing, why he's interested in the controversy. So if you did not have, let's say, a Bitcoin business that used Bitcoin at that time, you can't just, I couldn't just challenge the regulation because I didn't like it. You have to have some form of vested interest in it. That's, by the way, one thing that the Attorney General of the state of New York, which is a lawyer for the Department of Financial Services, so in front of us we have the AG, is arguing that Theo did not have standing. Well, that's kind of a bit crazy since he was trying to run a Bitcoin business. So that argument is going to be much simpler to deal with. The process by which this kind of lawsuit goes through is it's relatively quick because you don't really have what's called a lot of discovery, which takes years. Here it's very compressed in time. So by next spring, definitely a decision will be expected. Right now it's just a bunch of exchanges of motions and fights over procedures and things like that. But at the end of the process, is probably going to be around early next year. By the way, when you go to court and you settle with your, car insurer or whatever it is, right? There's a lot, the vast majority of lawsuits are settled, right? These Article 78s don't settle. Somebody has to win and somebody has to lose. And whomever wins, whomever loses, is going to end up what's called an appeal. There's two appeal levels in New York. One is at it's called the First Department downtown, which is the appellate court. And then the second appeal, which is essentially the highest court of the state of New York, which is in fact called the Court of Appeal. So that's really where a lot of these Article 78 gets to really be followed through in terms of content. So whomever wins will be very happy, and whomever loses is almost certainly going to trigger the two appeals. So this is not over in the spring of 2017. This will obviously continue.